My lords and my lady, I'd like to come back, if I may, briefly to a point that I made at the outset of my submissions, where I effectively contended that perhaps the reason that this matter only now comes before the court 22 years post-Ettridge was because lenders have done a relatively good job of dealing with these cases appropriately themselves. And I think it's helpful in that regard to go back to the judgment of the first instance judge, His Honour Judge Mitchell, and the comments that he made on the evidence put forward for the respondent. Can I take the court to page 107 of the appeal bundle, please?
Which paragraph is it in his judgment?
It's paragraphs 45 onwards.
Yes.
At paragraph 45, I should say the witness who was giving evidence on behalf of the OneSavings Bank was a Mr. Richardson, who was the group underwriting officer. And so in paragraph 45, he dealt with the fact that there hadn't been a requirement for independent legal advice in this case, which is one of the steps of the Ettridge Protocol. And then he went on at paragraph 46 on Judge Mitchell to describe the evidence as follows. He said, on the other hand, if a party was giving a personal guarantee, then the bank would have included in its instructions to solicitors provision for that party having independent legal advice. He said, given what he now knew, in other words, that it was now known that the net proceeds were effectively going to Mrs. Bishop, then the bank would have required Miss Waller-Edwards to get independent legal advice, but they had not known that at the time. Paragraph 47, he accepted the bank knew well that 20,000 was needed for redemption of car finance and 19,000 to Mr. Bishop's credit card. Indeed, that was a condition of the mortgage offer. He said it was not uncommon for a joint application to be made to consolidate debts and for debts to be in one party's name, or greater debt to be attributable to one party than the other. In this case, Mr. Bishop was the major wage earner, so it was not unusual that debts were in his name. And as far as he was concerned, or as far as the bank was concerned, the parties were in a relationship with joint expenditure. He expected that anything untoward to the contrary would have been identified by the brokers who put the package together before it came to the bank. And there's 2 points that arise out of this. Firstly, as I said in my submission, that banks have been getting along well with the tests that already exist, i.e., is this a surety transaction? If so, Ettridge Protocol applies. Is this joint borrowing? If not, this is analogous to CIBC and PIT, and there's no need to apply that protocol. And so effectively, albeit this fact and degree test is a novel one, which was first formulated by His Honour Judge Mitchell and upheld by Mr. Justice Johnson, I say that that is effectively, in my submission, based on the evidence that we have of Mr. Richardson, how banks have been operating, how lenders have operated in order to identify which transactions are those to which the Ettridge Protocol needs to be applied. And the second point that arises out of this is the question that your ladyship asked earlier of my learned friend, which is, do banks apply the Ettridge Protocol? And whilst it's correct to say that Mr. Richardson in his evidence said, I don't know what the Ettridge Protocol is, he also very clearly identified that there were scenarios in which the lender would have to take additional steps, and he identified some of the situations where that might be the case, and he also identified some of the steps they might take, and this is the summary of the evidence that he gave on that point. Can I take the court, please, back to Ettridge again, and page 65 of the authorities bundle. And this is further discussion within the speech of Lord Nichols. We've looked in some great detail at paragraphs 44 onwards, and what I want to now look at are paragraphs 48 and 49 on page 65. At paragraph 48, Lord Nichols said as follows: as to the type of transactions where a bank is put on inquiry, the case where a wife becomes surety for her husband's debts is in this context a straightforward case the bank is put on inquiry. On the other side of the line is a case where money is being advanced or has been advanced to husband and wife jointly. In such a case, the bank is not put on inquiry unless the bank is aware the loan is being made for the husband's purposes as distinct from their joint purposes. And the reference there is to CIBC and PIT. And he then goes on at paragraph 49. Less clear-cut is the case where wife becomes surety for the debts of a company whose shares are held in her and her, or held by her and her husband. Her shareholding may be nominal, or she may have a minority shareholding or an equal shareholding with her husband. In my view, the bank is put on inquiry in such cases, even where the wife is a director or secretary of the company. Such cases cannot be equated with joint loans. The shareholding interests and the identity of the directors are not a reliable guide to the identity of the persons who actually have conducted the company's business. And so effectively, there were a number of permutations that were considered by Lord Nichols and Ettridge, effectively the pure surety transaction, which, as he said, was a relatively straightforward case. The bank put on inquiry. The straightforward joint lending transaction, lenders not on inquiry, CIBC and Pitt, and the slightly more complicated scenario where you have a company structure in the middle.
So 49 is really the nearest that one gets to the present case.
It's the nearest, but it adds an entirely different factual scenario that doesn't exist here, because as Lord Nichols correctly says, the difficulty you have with where there's a company that's been imposed in the middle is that you have no idea what in fact the structure of that company is and who really benefits from it. And so, as he says, the identity of directors isn't a reliable guide to the persons who have the conduct of the company's business.
But in what way, in that case, is assuring the debts of the company different from assuring the debts of the husband, as happened here? I mean, the uncertainty in that case that Lord Nichols is pointing to is that the assuring the debts of the company might be to the wife's benefit, and that was uncertain because it wasn't known whether, for example, she was equally involved in the company.
Well, I
in
think,
this case, it was known that she wasn't, that the debts were not in her name.
But I think ultimately that supports my contention that this is a matter not simply of degree, but of fact. And I'll come on to address this in more detail, but I say that it's not only, and this is very much what Mr. Justice Johnson said on appeal, it's not simply a question of looking at, well, what percentage of this lending is...
But if you say it's a matter of fact, that might be said to go against you. In other words, if you don't know what the facts are, why should they be assumed to be in your favour?
But where you do know what some of the facts, or you know on the face what some of the facts you're being told are.
Well, on the face of it, it's his debt.
But it's not as simple as that, I say, even when you come to the factual question. And I'll come on to that point now because I think it's convenient to do so. Because, as I say, it's not simply a question of is it his debt or her debt or joint debt. Because there are, again, far more factual issues that I say a lender might need to consider. And this comes back to Mr. Richardson's evidence, which is that, for example, had the bank known that money was going to Mrs. Bishop, that they might well have considered this to be a transaction where the Ettridge guidelines applied. In terms of different factual possibilities, at one extreme you might have, and let's say we're talking about the same amount of money in every scenario, 90% is a remortgage and 10% is for the benefit of, on the face of it, the husband alone. But within that 10%, you might have a situation where that 10%, on the face of it, as far as the bank knows, is to be used for the husband's company. You might have a situation where that 10% is to be used to pay a car loan. You might have a situation where that 10% is to be used to pay a credit card debt. You might have a situation, even within that question of car loan and credit card debt, there are two possible factual scenarios. You might have a situation where the mortgage application is made to pay off the £500,000 or whatever it is, existing lending, and to pay off the car loan or the credit card. Or you might have a situation such as this one, where the application is not made to pay off the car loan and the credit card, but the lender says, if you want this money, we will make it a condition of our lending that you do pay that off, and it may be...
Is that the case here, on the facts?
I understood that to be the case, but I can perhaps check.
Because the judge describes it, Mitchell, describes it as a condition of the loan that these debts were discharged. Yeah, it was. So it wasn't them suggesting it, it was the bank.
Indeed. And this comes back then, in my submission, to the factual evidence we had in this case of Mr. Richardson, which is that it is not uncommon for what on the face of it looks like joint household debt to be in the name of one, either husband or wife, most commonly whoever happens to be the primary earner of those two. And this is, I think, the very important point that arises out of the judgment of Mr. Justice Johnson, because he makes very clear that he doesn't simply consider it to be a mathematical exercise of looking at, on the face of it, what percentage are we talking about. It's not simply a matter of degree, it's a matter of fact. And as I say, there are so many potential different factual scenarios as to what reason for this 10% or whatever percentage it is that is solely for the benefit of husband rather than wife. And I think another important factual scenario to look at is this. In this particular case, what we know is that the 90% that was, as far as the lender knew, going to be used for joint purposes, a substantial percentage of that was going to be used to pay off an existing loan on the property. That existing loan had already effectively expired and needed to be paid off as a matter of urgency. That might again be considered very different factually to a scenario where there's existing lending on the property, but there is no need to pay it off as a matter of urgency. And the sole reason behind the remortgage appears to be in order to release the additional equity to pay off the debts that are only in the name of the husband. And so what I'm seeking to illustrate is that there are so many different factual scenarios that a bank deals with on a day-to-day basis when there is a joint application for lending, where there might be a small element, a medium-sized element, that is on the face of it for the benefit of only one.
Well, would it help you to think of a different permutation, which I suppose can't be particularly uncommon, where both individuals have got debts? So let's suppose he had £40,000 of borrowing and she had £25,000 of borrowing, or whatever it happened to be. Does that help your argument in one way or another?
Well, I think it does. I think it's just, again, it illustrates another factual scenario. Because the question that arises in my submission, and I'll come back to this broader, but what one needs to do in considering all of these different possible factual scenarios, including that possibility, is to go back to the rationale of Lord Brown Wilkinson in Barclays Bank and O'Brien. And the rationale behind the whole concept of constructive notice or on inquiry in these lender, surety, borrower cases was to attempt to wheedle out those cases where there is, on the face of it, some sort of red flag.
Before we do, can we just pause a little longer on paragraph 49?
Yes.
The company situation. Because you were saying, well, there's lots of different factual scenarios. Even within this, the factual scenarios referred to in 49 include a case where there may be an equal shareholding, husband and wife in the company, yet there seems to be a sort of bright line. Any case involving a company, you're on inquiry. How do you fit that with what you say?
Well, I think it's for exactly the reason effectively given in paragraph 49, which is that where you have a company, it's not quite so easy to identify who effectively the controlling minds are. And so who is it that really is seeking this loan, this advance, this money to pay off this debt?
But with respect, don't we have exactly that situation between the husband and the wife? That's what I'm driving at, really. Well, the dynamics may be equally difficult to detect, and the House of Lords was effectively saying, don't go there. Don't try to get into that detail.
And I think that it comes down to a question of the whole purpose of the Ettridge Protocol and the guidelines and the constructive notice is about reducing risk of effectively transactions that have been procured by undue influence actually going through. That is a risk that can never be entirely eliminated. And contrary to what my learned friend says, it must be the case that the Ettridge guidelines, the Ettridge protocol, imposes on the lender an additional burden. And in my submission, it's therefore a question of balancing risk elimination versus burden and establishing what that correct balance is. The House of Lords could, if they wanted to, said, well, we consider risk elimination or risk minimalisation to be so important that, in fact, in every joint lending transaction, the Ettridge protocol ought to be followed. But they expressly rejected that in CIBC and Pitt. And so I say it must be a balancing act, and it must be, in my submission, about trying to identify those transactions that where there is some increased risk of the chance of undue influence or something else untoward. Because that was effectively what was said by Lord Brown Wilkinson in Barclays Bank and O'Brien. And I think it also comes back to the point that my Lord Jackson made to my learned friend this morning about does this not introduce an element of randomness in terms of the test that my learned friend suggests, because effectively what's being suggested is in a case of this nature, we have the appellant and Mr. Bishop have applied for a loan, and on the face of it, what they want that loan for, as far as the bank can see, is to pay off existing lending on the property that needs to be paid off and to put down a deposit for a new property to move into. In this particular situation, it so happens that the lender decides to make it a condition of the lending that Mr. Bishop's debts that are in his personal name are paid off, presumably for their own policy reasons or their own underwriting or their own, for whatever reason. Now, had they not decided to make that a condition...
It's for their own protection, don't beat around the bush.
But it's
they're protecting themselves. And what's an issue here is whether at the same time they have a duty to protect other people.
But they're not insisting that Mr. Bishop's debts be paid off in order to protect themselves from the risk of undue
It means so that they don't fall behind in getting their interest.
And so this is where I say that the element of randomness that would be introduced by my learned friend's proposed test, because effectively it would only be in those scenarios where a bank decides for reasons entirely unrelated to the risk of undue influence or something untoward, that debts in the name of one or both, indeed, of the borrowers need to be paid off as a condition of the lending, that suddenly that would be a trigger to put the bank on inquiry and the Ettridge guidelines apply, whereas if the bank didn't make that a condition, they wouldn't be in that scenario. And that's effectively the situation we would have been in this case. If the bank hadn't said, for an entirely unrelated reason, we need you to pay off your car loan and your credit card, we wouldn't be here having this argument.
But it doesn't really matter, does it? Because they did ask.
They did. But that's my point about the element of randomness that effectively would be brought into the law by my learned friend's proposed test.
I mean, just so I've understood what the figures amounted to. The judgment tells us that the previous mortgage, by the time it was redeemed, was 233,000.
Yes.
And this mortgage was 384,000.
Yes.
When it was granted. And so effectively, what's happened here, either through simple bad fortune for the appellant, or because you didn't do your duty, is that Mr. Bishop was able to get away with yet another 150,000.
Yes.
And the question is, what sort of forms of insurance or tripwires ought there to be to stop that happening with each successive lender making it possible for people to behave in this way?
Absolutely, and the case law is very clear that what we're dealing with here effectively are two innocent parties.
Yes.
And it's about the balance.
Yes, except you're a professional party.
Yes.
Who isn't affected by the sorts of things that affected this appellant.
But my point is this, should, whether or not we are put on inquiry, because effectively my learned friend's proposed test would cause this to be the situation that if it just had happened that Mr. Bishop didn't have a car loan and a credit card, and so we had lent on the basis of the application alone, we would never have been put on inquiry. But because he happened to have those debts that we, as a lender, said must be paid off, that we are then suddenly put on inquiry, even though there were no more red flags on the face of the transaction, nothing to put us on notice. Our own insistence that something be paid off be what put us on constructive notice, on inquiry. Because that, in my submission, is what my learned friends test, as a matter of fact, will cause to be the case. And I say that.
Well, I mean, your point, I suppose, is this, that if the borrowers come to the bank and say, we want to borrow for remortgaging and buying a new lovely house, you can't really have can't have a continuous evaluation of the type of transaction. You look at that and you say, okay, well, that's not going to be a worry, so we'll just go on with it, because solicitors are representing both parties. This is obviously a joint loan transaction, if we're thinking about Ettridge, which we should be. And then at the last minute, the underwriter in the bank says, hang on a sec, this bloke's got a bit of borrowing outstanding, shouldn't we roll that in? And the transaction changes character, so it's a bit of a trap for the unwary bank.
Yes.
But I think my lord might say, well, that's tough luck. They then would have to have not said that.
But this comes back to my point about what was the rationale behind all of this. It's about risk versus burden balance. And if what the House of Lords has intended was that effectively every joint borrowing transaction be dragged into the Ettridge guidelines, then they would have said so. And they could have said so, because CIBC and PIP was the opportunity to do that. But instead they made very clear in that case, and I'll come on to that judgment in just a moment, but they made very clear in that case that in joint borrowing situations, the Ettridge guidelines didn't need to be implemented. And the fact that in the last 15 or 20 minutes, between us, we've managed to come up with at least 7 factual scenarios, I think in my submission indicates exactly the point that I'm trying to make, which is that this must be a matter of fact and degree, that lenders have routinely treated it so, and it's simply a matter of fact and degree in terms of establishing, is this, on the face of it, a surety transaction, or is this, on the face of it, a joint borrowing transaction?
When you, just to clarify, I think one of the elements of what you're saying is effectively that you're looking at the stated purpose of the loan. And if the bank doesn't have information to go behind that, then you stop with that.
I think that certainly would apply in this case, and it might apply in an awful lot of cases. There might be cases where it's not that simple, because there might be more than one stated purpose of the loan, and that's where you might then come back to a question of degree. But certainly on the face of this particular case, I say yes, you could look at this. You could limit it to looking at the stated purpose of the loan. Can I take the court back to the judgment in CIBC and PIT? Because I think, as I said, that's helpful. At page 32 of the authorities bundle, and this is the judgment of Lord Brown Wilkinson in PIT. And it's at C, the paragraph towards the middle of the page. So far as the plaintiff was aware, the transaction consisted of a joint loan to husband and wife to finance...
Sorry, which paragraph are you on?
Paragraph C on 32.
Sorry, yes, thank you.
The transaction consisted of a joint loan to husband and wife to finance the discharge of an existing mortgage on 26 Alexander Avenue, and as for the balance to be applied in buying a holiday home. The loan was advanced by both husband and wife jointly. There was nothing to indicate to the plaintiff that this was anything other than a normal advance to husband and wife for their joint benefit. And it's that final sentence that I say is important. There was nothing to indicate to the plaintiff that this was anything other than a normal advance to husband and wife for their joint benefit. And I go on then to the next paragraph. It accords with neither justice nor with practical common sense if third parties to be fixed with constructive notice of undue influence in relation to every transaction between husband and wife. Such transactions would become almost impossible. Now I pause there for a moment, because I think one of the points that my learned friend has made is that requiring a lender to apply the Ettridge Protocol every time there's anything other than non-trivial lending for the benefit of one partner, he suggests doesn't add any undue burden on the lender. Well, that was expressly rejected by Lord Brown Wilkinson in Pitt, who made it very clear that fixing a lender with constructive notice in almost every transaction between husband and wife would become almost impossible. It's very clear from that that he considered that there would be a substantial additional burden placed on the lender. And he went on every purchase of a home in joint names, the bank or building society financing the purchase would have to insist on meeting the wife separately from her husband, advise her as to the nature of the transaction, and recommend her to take legal advice separate from that of her husband. If that were not done, the financial institution would have to run the risk of a subsequent attempt by the wife to avoid her liabilities under the mortgage on the grounds of undue influence or misrepresentation. To establish a law in that sense would not benefit the average married couple and would discourage financial institutions from making the advance. Again, I say an important point in the rationale of Lord Brown Wilkinson in Pitt for rejecting the contention that in a joint borrowing transaction a lender was put on notice or on inquiry.
Which paragraph is it, please? Sorry, which page?
32. And then finally at G, what distinguishes the case of a joint advance from the surety case is that in the latter there is not only the possibility of undue influence having been exercised, but also the increased risk of it having been exercised, because at least on the face of it, the guarantee by a wife of her husband's debts is not to her financial benefit. It is the combination of these two factors that puts the creditor on inquiry, and that's effectively a restatement of the test in Barclays Bank and O'Brien. Now, before the short adjournment, the court asked my learned friend about the Ettridge guidelines and effectively what would happen if the bank decided, well, we're just going to ignore them or didn't comply with them properly. And in my submission, a lender who acted in that manner would find itself in real difficulty and would find itself in a scenario where it effectively didn't have the protection that it would have if it complied with those guidelines. Lord Nichols' speech in Ettridge sets out the guidelines, and if I could take the court, please, to page 72 of the authorities bundle. At paragraph 79 of his judgment, Lord Nichols says, I now turn to the steps a bank should take when it has been put on inquiry and for its protection is looking to the fact that the wife has been advised independently by a solicitor. And Lord Nichols then went on to set out the various steps, and he summarises them as 4 bullet points. And if I could take the court over to page 73 to bullet point 4, the bank should in every case obtain from the wife's solicitor a written confirmation to the effect mentioned above. And there seemed to be some suggestion by my learned friend that what the bank could effectively do is write to the wife, and if she writes back and says, don't worry, it's fine, I don't need my own independent legal advice, well, that would short-circuit it. That's very much not what's indicated by the speech of Lord Nichols in Ettridge. Can I also take the court to page 90, which is the judgment of Lord Hobhouse in Ettridge? And at A, at the top of the page, if the solicitor does not provide the statement and certificate for which the bank has asked, the bank will not, in the absence of other evidence, have reasonable grounds for being satisfied that the wife's agreement has been properly obtained. And so in my submission, it's very clear that compliance with the Ettridge guidelines imposes on a lender an additional burden, and in my submission a substantial additional burden. Not only that, but it actually imposes on the borrower.
Well, it's fairly obvious who ends up paying for the advice.
Yes.
Probably not the bank.
Exactly, indeed. And so both from a practical perspective and a financial perspective, it imposes on borrowers an additional burden. Now, of course, that additional burden is appropriate in certain circumstances. It's clearly appropriate where there is an increased risk of the chance of something untoward, undue influence, misrepresentation. And the House of Lords has identified that that risk is increased in a surety transaction. It's equally identified that that risk is not sufficiently increased in a joint borrowing transaction, such that it ought not to be necessary for the Ettridge guidelines to be implemented in a joint borrowing situation, unless, of course, there is an additional red flag on the face of it. And there will always be additional cases where there's some other red flag. But I say it's extremely important to bear in mind that rationale and that policy approach and the distinction between the surety transactions where there is an increased risk, or at least on the face of them, and joint borrowing where if there is any increased risk, it's so minimal such that the House of Lords has said you don't need to apply Ettridge when one considers how to deal with these hybrid cases. And that takes me back to my primary submission, which is it must be a matter of fact and degree to establish, is this something where, akin to a surety transaction, it's not on the face of it to the advantage of the wife, and so there is an increased risk of something undue influence.
And I suppose you might say that in the company case, it is actually a surety because you are being surety, standing surety for the company.
Yes.
And the thinking, the rationale of that carve out is, well, you can never quite see that is not standing, that is not joint borrowing
Yes.
in any proper sense.
I think the reason that the word surety has been used is because these cases were initially considering, historically, situations which are much more akin to a traditional surety situation, i.e. it is the debts of a company of the husband which he seeks to secure as against the property, and so effectively as against the wife's interest in the property. And that's why we're now using the language surety, albeit it doesn't seem to perhaps be so factually appropriate to the situations that we now find ourselves dealing with. I think I must deal briefly with UCB and more, unless the court of the view that it isn't necessary for me to do so because it was flagged
We're
up.
not of any view at the moment.
Well,
We need you to deal with whatever you think you need to deal with.
I'll deal with UCB more briefly in that case, because as my learned friend said, it was flagged up in the reason for granting permission for this appeal. In that case, the mortgage advance was $300,000. Half of that was to be used to pay off an existing mortgage on the property. 1/6 was to be used to discharge a company overdraft that was already secured on the property, and the rest was as by way of a further loan to the company being a company in the name of the husband alone. And the issue that came before the House of Lords in that case was a question of whether or not there had been reasonable steps taken by the lender. In particular, it was a question about whether reference on the application form to solicitors acting for both surety and debtor was sufficient. And so, whilst factually there was a scenario that in some ways was similar to our case, i.e. some lending for the benefit of both, some lending for the benefit of one only, that question simply wasn't being considered by the House of Lords. And all the House of Lords concluded was that there was at least a triable issue on the primary question in that case, namely whether reasonable steps had been taken. But at no point in anything I've read was there any suggestion that the element of payment to the company alone was sufficient to place the lender on inquiry. Indeed, as far as I can see, it simply wasn't considered. And indeed, we have very limited information about the factual matrix of that case, and it sounds as though my learned friend's valiant attempts to get more information from somebody involved at trial level came up against a brick wall. But as I said earlier, in support of my contention that it's a matter of fact and degree, one point that I suggested might be relevant is whether the existing lending secured on the property needs to be remortgaged as a matter of urgency or not. And we simply don't know in this particular case whether or not that lending did need to be paid off as a matter of urgency to fend off repossession. So in short, my submission is that UCB and Moore doesn't assist this court at all. Can I take the court to the judgment of Mr. Justice Johnson on appeal at page 68 of the appeal bundle? And this is the paragraph that we looked at earlier during my Learned Friend submissions, at paragraph 79. I, for completeness, will read it out again. As a matter of general principle, it seems to me that the O'Brien principles are not confined to those cases where the wife or other person is acting as a surety for the entirety of the relevant mortgage loan. The principles are clearly more flexible than that. It seems to me they're capable of extending to mortgage transactions where the position is less straightforward than the wife or other person acting as surety for the entirety of the relevant mortgage loan. Indeed, this may be said to follow from Lord Nichols' analysis of the position in Ettridge of a wife becoming surety for the debts of a company in which she holds shares. On this basis, it would seem to me that the O'Brien principles are capable of extending to what I would call a partial surety case, where the wife or other person acting as surety in respect of a part of the mortgage loan. As I understood the submission of Ms. Halker, she did not argue to the contrary. And then on to page 70, to paragraph 89, This, however, leaves the questions, one, of how one identifies partial surety cases to which the O'Brien principles can conditionally be applied, and subject to the answer to this first question, two, whether the judge was right to decide that the respondent was not put on inquiry in the present case. And it's effectively the first of those questions that this court is now grappling with. And at 90, the answer given by Mr. Justice Johnson, it seems to me that the answer to the first question must necessarily be a fact-sensitive one, by which I mean it must depend upon the facts of the relevant case. And then over to paragraph 94 on page 71, it seems to me that in deciding whether the present case is a partial surety case, where the respondent knew or should have known that the appellant was acting as effective surety for Mr. Bishop's personal debts, the exercise is not simply a numbers exercise. I do not think this question is answered simply by asking what proportion of the remortgage loan, the sum of 39,500, represented. Instead, it's necessary to look at the transaction constituted by the remortgage as a whole. And Mr. Justice Johnson then goes on to consider what the remortgage looked like on the face of it as a whole to the lender in this particular case. And in short, my submission is that that was plainly the appropriate test to apply.
I made a note beside this particular passage where the judge says whether the remortgage was or should have been perceived by the respondent as a transaction which was not to the financial advantage of the appellant. If this is the right way to be going, isn't on any view the test whether it might not be to her financial advantage? Aren't we talking in O'Brien land about possibilities?
I think the difficulty is that there is always the possibility.
No, but I mean a test that you've got to reach a conclusion that it is not for the financial advantage of your borrower. Isn't that on any view putting it too high?
I think you're saying is not to the financial advantage on the face of it. And I think that's the important
But if
point.
we're talking in the language of risk, which is what all this is about, I mean, should the judge, even if he was right to say it's a matter of fact or degree, and I'm not carping with this very careful judgment, it's just a matter of reflection on what is said, would it not have been more accurate if he's applying the authorities that we've been looking at for him to have said a transaction which may not have been to the advantage?
Quite possibly, and I certainly wouldn't quibble if your lordship's relationship were to make that finding, but I say that doesn't change the ultimate question, which is that it must be a matter of fact and degree. And I say it's a matter of fact and degree as to whether or not this is akin to a suretyship transaction or akin to a joint borrowing transaction.
But just on that, the words the judge used do appear to reflect what we're told by Lord Nichols is the rationale.
Exactly.
And the part A of that rationale is it on its face not to the financial advantage. So I think the judge you may need to accept, or it certainly seems to me that the judge is applying that as the test.
Indeed, and that ultimately, it really is my overarching submission is that what one has to do in order to search for the answer in this case is to go back to the rationale. The rationale is the A and B from Lord Brown Wilkinson's speech in O'Brien that was quoted by Lord Nichols at paragraph 44 of Ettridge. And so in order to find the answer to the question that troubles this court, one needs to go back to that rationale. That rationale is to look at the transaction, and on the face of it, does it appear to be to the financial advantage of the wife? In a surety transaction, it will not on the face of it appear to be to the financial advantage of the wife. In a joint borrowing situation, it will.
Is there something in the point that a joint borrowing is always going to have conditions? And if you borrowers went along and said, we want to remortgage, pay off a load of debts by one of us, and get some money out for us, then the transaction might genuinely be a hybrid transaction, and it might genuinely on its face not be capable of saying this is a joint lending transaction. But if the borrowers go along and say we want to go and buy a lovely house and remortgage for ourselves, and the bank says, well, you can only have this money if you also pay off the husband's debts, that's really quite a different situation.
Exactly, and that's why I say it's a matter of both fact and degree, because as my Lord Jackson indicated earlier, you also potentially have a scenario where both husband and wife have individual debts in their own name that need to be paid off.
Yes, but that might be a situation also which would not be a case necessarily of entire joint borrowing.
Indeed.
If that's what they went there for. But if they, I mean, the way I see it at the moment is that it really is, you have to look at this through the lens of the bank.
Yes.
And it's all very well to say, well, this is a terrible thing, but these authorities tell you to look at it through the lens of the bank. And if two people come and say, we want to borrow for this and that, for ourselves, then to say that's a hybrid or not really a joint borrowing is really not easy to, I mean, you can get there by saying, well, you have to do it at the moment it's signed up. But, you know, then when you sign up, there is an element which is a surety, and if that element is in any sense non-trivial, then you should go through the protocol. But a more sort of straightforward, common sense approach, which is the one that, for my part, I see in this, is really there are only, it's what you were saying earlier perhaps, there are really only two types of thing. There's a joint borrowing thing and a surety thing. And it will be a surety thing if that is part of the intention, that's what it's about. But it won't be if that is just something that appears in the transaction because the bank says it's got to, and you can't have the money for your joint purpose if you don't. But I mean, it's a sort of compromise. It's a bit wishy-washy, isn't it?
But we have the evidence of Mr. Richardson in this case that this is extremely common. That it's very common for there to be debts that are in the name of one or other of
Imposed
the
then to be paid off by the bank?
Indeed.
Did they, I mean, just as a question of fact, were these debts with the bank?
No. One of them, I think, was BMW.
Well, I know the car wasn't.
The car wasn't. The credit card, by my recollection, was entirely unrelated. But
how did they find out? Because they put in an application
Yes.
form and they were asked, have you got any other debts?
and the application was before the court at first instance, and it would list income, expenditure, debts, etc.
Yeah, okay.
They get it on a credit check, I think.
Yes.
But then if you're focusing on, you know, what do the couple go along and say they want the loan for? If they happen to have recognised that we're paying there is a really high rate of interest on this credit card debt, so we'll put that on the form as well. That rather suggests that might make a real difference, whether they put it on the form or not.
But I think that has to make a difference, because it has to be what the lender sees, what the lender knows about, whether there are effectively red flags on the part of the lender. And we helpfully have, again, his Judge Mitchell's summary of Mr. Richardson's evidence, which is that the bank would have treated this transaction very differently in different factual circumstances, had they known that 142,000 was going to Mrs. Bishop, had they known there was a deed of trust in this case, that in fact the property was held in trust 1% to Mr. Bishop and 99% to Ms. Waller-Edwards. Again, had the lender known about that, they'd have treated this very differently.
Why?
Because they would have known that effectively 99% of the equity in the property was Ms. Waller-Edwards, but that nevertheless she was putting that equity up to pay Mr. Bishop's ex-wife off.
Oh, I get the 140,000 for the ex-wife. I mean, why would it have been different if they'd just known that the equity was 99.1?
Oh, well, it was a combination of those two things that Mr. Richardson said would have made the bank treat this very differently.
Well, I think I'm not meaning to be rude, obviously, but
Yes.
But if they didn't know about that, if it was all for a joint house in the south of France, I'm not sure I see the 99.1 making a difference.
Well, I suppose we don't have evidence from Mr. Richardson about whether or not solely that point would have made the difference, because his point was globally knowing these factors would have made the difference.
Okay.
But effectively that takes me back to my point, which is that the fact and degree approach appears on the face of the evidence of Mr. Richardson to be the approach that banks have been employing.
Well, this bank.
Certainly this bank.
Yes.
Since
it's not for the bank to determine whether that's the right.
No, indeed, it's not.
But
But one of the questions I was asked at the outset, and one of my learned friend's contention is that that his test would somehow benefit lenders as well, because it would give them some more certainty. But my submission is that they've been getting along just fine.
Well, I mean, you can't really make that submission. I mean, you can. Well, I mean, you can. We're not stopping you, but it isn't really. We haven't got any evidence. I mean, this is a very odd case, because I actually feel, anyway, speaking for myself, we would really have benefited from some expert evidence about what's happened since Ettridge in the real world of banking, but we haven't got it. So, I mean, we wouldn't have benefited to construe the judgments we're supposed to be applying, but it would have been very interesting, because if we get to policy, and Mr. Beaumont suggests we get to policy, and I can see that if there's a choice as to what is good and what is bad, policy might be said to be relevant, then such evidence would be beneficial. But I think when you went to trial in front of Judge Mitchell, you were a million miles away from thinking you'd end up deciding what the policy of lending ought to be.
Indeed, and so unfortunately, effectively what we have is his Honour Judge Mitchell's summary of Mr. Richardson's evidence, together with...
Yeah, we can't extrapolate from that. The point
No.
I'm making, we can't extrapolate.
But we do also have the rationale behind the rejection of the extras principles applying to joint lending in PIT.
Have we got any evidence about what the bank is? Is it a, again, not meaning to be rude, but is it a tertiary lender, or is it a fairly mainstream lender? What?
Can I turn my back?
Yes.
It was formerly known as Kent Reliance Building Society, which
okay.
the bench may well have come across. Effectively a mainstream lender.
It's a mainstream lender
Yes.
with a new name.
Yes.
Could I just, I'm sorry to ask you to do my homework for me, but just to get to fix all this. But, they made an application to you for originally 440,000, although you were not willing to go quite that far.
Yes.
And it was, I haven't quite got clear in my mind what you were exactly told that 440,000 was going to be spent on.
So my recollection of the factual matrix was that it was to pay off the existing lending secured on the property.
That was 233 by
No,
the time.
it was only 200 when they were originally asking.
Right, but it presumably it wasn't being paid, and so it rolled up to.
And the rest of it was because what was being taken out was what's called a let to buy mortgage. And so one of the conditions of that mortgage would have been once we've lent you this, you can no longer live in that property. Because it has to be let out. And so the rest of the money that was being released, the additional lending over and above the 200,000, was to then purchase a further property in which the lender was told Miss Waller-Edwards and Mr Bishop were then going to live and rent out Spectrum.
Right, and was there any evidence that such a property ever existed?
No. And indeed, I think I can, if necessary, take the court to this, but Mr Richardson was asked about what inquiries were made by the lender about that, and he effectively said, as long as we're told that that's what it's for, we don't make further inquiries about whether.
I mean, there wasn't any argument at trial complaining about the failure to make inquiries about what was to happen to the 142,000. There was, I mean, it could, I would have thought, in theory, have been a different defence. It could have been said, you knew this was dodgy, there was no evidence of it, blah, blah.
So that was one of the points my learned friend took, but it was one of the points that was rejected by.
And not a big.
That was matching the accounts, wasn't it? The same figure.
There was that as well.
In two places, and the bank didn't spot it.
Exactly that, but there was also a point taken that perhaps the lender ought to have asked for evidence that the new property had been purchased, etc.
But I'm just interested in understanding that you're prepared to give away this amount of money.
No, banks don't give.
No, with other people's money. You're prepared to pass over six figures and some on people's say-so.
Well, on the basis of underwriting decisions about the affordability. So again, the evidence of Mr. Richardson.
This second house, the one that was going to be bought so that this other place could be bought, so it could be let, was an invention.
It appears so, yes. Well, we don't know whether it was in the minds of Mr. Bishop and Miss Waller-Edwards at the time when they changed their minds, but certainly it appears it was an invention. But Mr. Richards' evidence was very clear that the underwriting department would make their financial checks to ensure that what was being lent was affordable in terms of repayments, and that was done.
Right. Yes, thank you. I mean, the amount that was involved was left for the new property was a couple of 100,000, 150,000, something of that sort.
Well, it would have effectively been the amount of money that was used for Mrs. Bishop, so it was about 143,000.
Well, less the credit card debts, etc., because they weren't paid off. If you took, it's even less.
Yes.
It's 100,000.
I'm just wondering what you get on the South Coast for 100,000.
Well, again, there was discussion about that at first instance, and Mr. Richardson's evidence was that the bank would assume that that was going to be a deposit to put down, and then further lending perhaps be taken out by a residential mortgage be taken out by another lender. So this was effectively equity release to get you the deposit, then take out another residential mortgage and buy a property that way. So that's what it appeared to on the face to this lender, and that's in my submission is extremely important. The court has to remember that it's what it appears on the face to this lender, because it turns out behind the scenes there are all sorts of very dodgy things going on, but that's not what appeared to us on the face to this lender. It very much appeared to be an application by joint owners who were in a relationship to let out their existing property and buy a new property in which to live. And as a condition of that lending, this lender said, by the way, you also need to pay off your car loan and your credit card debts. Those happen to be in the name of one or other of them. But in my submission, is that a situation where it was intended by either Lord Brown Wilkinson or Lord Nichols that a lender would be put on inquiry and have to follow the Ettridge Protocol? And in my submission, it wasn't. And so I say that the first instance judge and Mr. Justice Johnson were right to find that in these hybrid type scenarios, it must be a matter of both fact and degree as to whether or not a lender is put on inquiry. Can I assist your lordships and your ladyship any further at this stage?
Yeah.
I appreciate that the answer will always be, in a sense, it depends. But could we think of a situation in which you might accept or come to accept that the balance had tipped towards there being, in a hybrid situation of this sort, a duty to inquire?
Yes.
Or a duty to advise and warn? Where would that kick in, would you say?
So even if we're talking about the same amount that we're talking about here, let's say we're talking about $200,000 to pay off existing borrowing. We're talking about some additional lending to buy a new property jointly, and then we're talking about £40,000 or thereabouts to pay off Mr's debts. There might be two different facts that made that a surety transaction rather than a joint borrowing transaction. First of all, if the £40,000 was to go to a company in the name of Mr, secondly, that the purpose of the application was said on the face of it to be partly because they wanted £40,000 to pay off debts of Mr's company.
Right, so if they'd asked for the sake of our argument, saying that might have triggered, if they'd asked rather than you required?
Well, not simply they asked, but also, as I said, that it was his company. And the third fact I say that might affect it would be if the existing lending didn't need to be paid off as a matter of urgency in the way that it did in this case. But so effectively, rather than the main purpose of the transaction being let's pay this off, the purpose seemed to be let's release some extra equity.
Sorry, is it uncontroversial that it was apparent to the bank that the first mortgage had to be paid off?
I believe so, but my learned friend could correct me if I'm wrong.
Well, it was overdue.
I didn't pick that up, but I may have.
You say it was overdue?
Yes.
But whether that was apparent is not.
I can certainly check, but that was my recollection.
So can I get these particular? You've posited three different things that might tip it the other way.
Collectively.
Oh, it's all together.
Yes, so I say collectively, we're talking about the same amount of money as we are here.
Right.
But those were the facts rather than the facts.
Could you just list the three again?
That there was no urgent need to pay off the existing borrowing. Right. That the purpose of the application on the face of it said, we want some of this money to pay off Mr's debts only.
Yes. And
in particular, if it was Mr's company, rather than what we have here that looks like it may well be joint household.
It may be obvious to others, but it's not obvious to me why that would make it any better, because I appreciate that by paying off his loans, he was getting off from under an interest obligation, would have been very unattractive, but in a sense, that was just a gift to Mr. Bishop.
Because Mr. Richardson's evidence here is that it's not uncommon to have these what look as though they are effectively household debt, but they're in one person's name. So a car loan,
the fact it's not uncommon means that it's also not uncommon for it to be the other way around, that it's somebody's selfish spending.
But that might still be considered to be household debt. And so my submission is that a bank may well look at these things very differently, where they're looking at what appears to be household debt that they are making a condition of the lending be paid off versus
Companies.
a debt to a company for which the lending is sought.
Thank you very much.
Thank you. Yes, Mr. Ben.
By way of reply, one has to distinguish in my submission between whether the wrong test was adopted, and if it was, what that test should have been. And this is the high point of my submission. Running like a golden thread through the judgment of Mr. Justice Johnson is reference to the whole. Having founded himself on the on its face test in O'Brien, that, which I have called a misnavigation, involved the learned judge, yes, looking through the bank's lens, as he had to, but it was a lens set in advance to view the whole rather than important detail. And if that is right, this judgment cannot stand. That's my first point. So one distinguishes between whether the wrong test was adopted and if it was, what the right test should have been. So I submit the wrong test was adopted because one can follow through without slavishly rereading it all and find pointers that show very clearly that the learned judge was looking at the whole. I'm trying to find those pointers as I speak.
Well, I don't think you need to. I think it's, if I may say so, fairly uncontroversial.
Well, I hope so. I hope so. Now, if that's right, leaving aside all the other interesting issues for discussion, if that is right, the scenario is one well known to this court where, unfortunately, the judge has, as it's alleged in the grounds of appeal, erred in law. He has did apply, what in truth was no more than a rationale and not a test, as was explained by Lord Nichols in Ettridge. Where does that leave us? First of all, the next question would be, well, what about the circuit judge? In fact, the circuit judge did exactly the same thing. He looked at the whole. His approach was holistic in the way that Mr. Justice Johnson's approach was holistic. So the first important step faced by a challenge faced by the appellant is met, in my submission, by demonstrating that both judges erred in law. I suppose in some ways that might be enough, if this were a different division, the matter would be sent back, to use the common terminology, for reconsideration, in this context a retrial, I suppose. But this court is going further in the analysis and considering, right, well, if the wrong test was adopted, what's the right test? And you know my submissions in that respect. I won't repeat them. It is a test that, without artificiality, ought in my submission to be calibrated so as to encompass, as far as one can do it, all relevant conceivable scenarios, but in particular the scenario with which this court on the facts is faced. Of course, there's another corollary, which is, well, what if Beaumont is wrong, and we're not interested in this suggested tweak to the test, but we're driven back to the Ettridge test, having decided to set aside the judgment below for error of law. That is, logically, another analytical outcome in my submission. And nothing that my learned friend has said drives one away from the conclusion in my submission that the Ettridge test as it stands accommodates the facts of this case, and that the £39,500 element did place the bank on inquiry. Was it small? Is a relevant question if one gets to this point in the reasoning. No, as I've already submitted, it was more than 5 times, and the bank knew that it was more than 5 times my client's income, which was a very small pension income of £7,000 odd per annum. So it had that piece of knowledge as well. It is wholly artificial in my submission to submit that whichever test is applied, that the bank did not know that there was a surety element to this transaction. And it makes no difference in my submission whether the personal loan element was imposed by the bank as a condition of the advance, or whether it was part of the purpose behind the application. The fact is, the surety status of the £39,500 is not different. It doesn't become any less a surety status because the bank requires that sum to be discharged, as opposed to it being part of the purpose of the application. There are various matters that I didn't deal with, really, through lack of time. And I just draw your attention, if I may, to my grounds of appeal number 17. I won't read it out, but it deals with...
Do you mind, before we just leave where we were
Yes.
Before a moment ago, the judge states at paragraph 137, I'm talking here about the first judge, at page 124, paragraph 137.
Yes.
That the question of whether credit card debt should have put the bank on inquiry is a matter of fact and degree. You have that point in the judgment.
Yes.
I was just trying to remind myself what the argument had been about that. Is the phrase matter of fact and degree something that was canvassed in the argument, or is
Yes.
it something that the judge...
I remember the judge asking me, and I agreed with him, that on the evidence as it was presented, the problem could be approached as one of fact and degree, and then that 10% was enough by way of fact and degree.
So
There is that scenario, yes.
right. So the trial judge approached this on the basis that the law was, as the respondents to this appeal argue.
Yes.
And that's why I think this expression, this is a matter of fact and degree, is dropped into the judgment without any fanfare, because that was common ground in the court below. It's just simply you said that, as a matter of fact and degree, it clearly is a surety
Yes, that's a
transaction.
classic
So-
county court submission where one doesn't have the opportunity to challenge the law as it is.
Well, no, it's quite possible to say this isn't what the law ought to be, but I have to live with this. But at what point did the test then rear itself as being an issue?
I would have to...
When did you first make the case
I
that
think
you're now making?
we have to, my High Court skeleton argument is in the bundle, as are the grounds of appeal, beginning skeleton 147, and is required under the rules to be in this bundle. It's an interesting question. I think the answer, I'm very bad at remembering how cases develop, but I think the answer is that I have focused today on the test, because the permission to appeal direction of Lord Justice Lewison gives me no greater elbow room. And so that is why I'm addressing the question of the correct test. And that just looking at paragraph 17 of my skeleton below, it looks like I was arguing about misapplication of the fact and degree approach.
So,
Looks
I'm sorry, I haven't fully appreciated this. So, I don't want to misrepresent it, I'll just put this to you for your comment. The legal argument that you're making to this court is not one that you made to either of the courts below.
well, actually, paragraph 28, page 153, I submitted. It submitted, therefore, a simple trigger test on inquiry
All right.
arising from some non-de minimis element. So there we have
What's that?
the point
Which
developed.
paragraph?
28.
28 of what?
My skeleton below, my lord.
So page 153.
Oh, skeleton below.
Yes,
I'm
page
just trying to
153.
trace back. where
Trying
this
to trace
argument
back how I got to this point.
developed.
I submitted there the simple trigger test on inquiry arising from some non-de minimis element of a loan for the exclusive purposes of the dominant party rather than the subservient party readily shifts the burden of disproof and constructive notice to the bank. The factual focus of the court was intended by the House to be on the way in which the bank has or has not taken reasonable steps, not on the divergent proportions in which, or divergent purposes for which, borrowers borrowed to pay off the debts of one partner or the other. And then I introduced this point about de minimis. So clearly there I did address the question of the test.
And then we have your grounds of appeal
From below,
to the High Court,
yes.
which are at paragraph page 143. Could you help us, because I'm only reading these at speed,
Yes.
and we obviously are only concerned with the first ground because the second one was to do with the statute.
Yes, we're not dealing with that.
Where in the grounds of appeal do we situate the argument about the legal test?
D, for instance, the sum of 39,500 is the surety type component of the transaction, was therefore indicative of possible undue influence. Outward signs were this was an emotional relationship, etc.
But this is all these are all supporting and simply what you described as an error of law in failing to find that the bank was on inquiry. It wasn't the argument that you're addressing to us.
Well, as I say, the argument I'm addressing to you has gone through the single judge filter. And the single judge filter, even though my grounds of appeal to this court were broader, the single judge filter is quite clear, very clear.
Well, I don't make, you understand, I don't make this point in a sense of criticism. I'm just saying that the point has emerged,
Yes.
as it were, clearly stated for the first time in the ground to this court that you were permitted.
Well,
To advance or not really?
one can see from my first sub-ground of appeal, to be fair to me, that I have pleaded that the transaction ought not to have been viewed as a whole in such manner as to treat the large part of the advance that was on its face, not to the appellant's financial advantage, as being submerged, etc. So the articulation of the test has been grappled with in these grounds of appeal. And the reason for that is that the judge below viewed the response to my first appeal as involving invocation of this holistic test. So in one little one of my grounds, that is what I'm training my fire on. So, and what's more, the judge below made the point clearly that in an area of evaluation of facts and evidence, the appeal court is very reluctant to interfere. And so, in deference of that restriction, the design of this appeal has to be more abstracted and more technical. And that explains 1.1. And again, to be fair, in my submission, here I am in reply, still making the same point. So there is consistency. I'm challenging what I have to challenge, which is the judgment below.
Thank you.
Anyway, I hope that's sufficient explanation.
I think, were you going to subground 17?
Yes, thank you, my lady. I was just going to draw your attention to the fact that I pleaded at little 17 that the bank may be placed on inquiry merely from the superficial knowledge that the daughter is offering to secure the debts of a parent. And then those, again, familiar words, that bare fact is enough. See Ettridge at 84, thus the House envisaged that bare or superficial knowledge of facts, for instance, a relationship alone, would suffice to place a bank on inquiry, ergo other types of superficial knowledge. And here, that approach translates into knowledge of the £39,500 component of the advance. And in the same way I pleaded there, that bare fact was enough. Whether that is an argument directed to a tweaked or new test or a critique of the way in which the Ettridge test was applied is, I suppose, open to question and criticism. But I have certainly accepted from the off today, and in preparing for today, that I have to formulate my attack as a legal one in terms of the correct test, because I have no greater elbow room by virtue of Lord Justice Lewison's order. So you could say that my little 17 here is an attack on the exercise of evaluation of facts below. I accept that. Learned Friend's suggestion that there are two baskets rather than three, to use Lord Justice Jackson's metaphor, is, in my submission, really one-dimensional and rather myopic, because the tests that were posited in Ettridge sprang out of the facts of that series of cases, and it's perfectly well known to the law that new cases and new facts from snails in ginger beers onwards, in ginger beer bottles onwards, may require new analysis. Learned suggested at the outset that the Lord Nichols speech was framed with pure guarantee cases in mind. Maybe that's how he began, but the analysis was much broader than that. You will have noted in Learned Friend's reference that this bank, in its evidence, who, through Mr. The gentleman, I can't remember his name offhand. Richardson, thank you very much. Made reference to reliance on the broker. And I shall say no more than that was obviously inadequate. And no bank should be relying on broker intermediaries in order to satisfy what is essentially due diligence. I was going to make the point there's no evidence here as to the practice in the industry, but I needn't do so. In the if one gets to the point in the reasoning that the holistic approach is rejected, therefore the judgment below cannot stand, now it may be that for this appellant's purposes, as I suggested earlier, it's not necessary to go further. But if it is necessary to go further, I do commend the test I suggested, because it has all the positive hallmarks that the original Ettridge test undoubtedly had, including simplicity, but perhaps more importantly, versatility, in that it responds to a great number of potential scenarios and would respond to all of the scenarios that my own friend portrayed in her submission. And it is, by way of rationale, a matter of the reduction of risk. Elimination of risk is probably impossible. But none of those propositions, which are policy propositions, are novel at all. They all spring from Ettridge. The notion of randomness, insofar as I understand it, could equally call for a versatile test that covers potentially as many different factual scenarios as it possibly can. And what has emerged in this appeal, in my submission, is that the Ettridge test is a bit too rigid and does need adjustment. Warnings about administrative burdens on banks are, first of all, clearly not based on any evidence whatsoever. I suggested, also not based on any evidence whatsoever, that the 9 Ettridge criteria in the protocol could be satisfied easily by a single letter generated by a computer. I may or may not be right. I suppose that's the other side of the coin, of Malone and friends saying, well, gosh, we can't be expected to do all this. But her submission is non-empirical and is little more than speculative scaremongering in my submission. Lady Justice Falk referred to the cost of requiring borrowers to obtain solicitor advice. And whilst one has seen some terrible examples in solicitor attendance notes over the years of inadequate advice, adequate advice is not actually difficult to come by if the solicitor directs himself or herself properly, and therefore should not be overwhelmingly expensive. And in any event, one is talking about transactions in the hundreds of thousands, where adding a legal fee to the mortgage debt is neither here nor there. And in fact, one would expect that the legal fees added to a new mortgage debt or remortgage debt would be less than some of the other administrative fees that one knows are already
Is the
added.
practice that the legal fees, for example, if they've got one solicitor for 3 parties, that's simply added to the mortgage debt?
I can't say it's a common practice. It must depend on the lender. It must depend on.
I would be interested to know if it's not to ask you to give evidence, but just if there's a clear industry understanding that if you're asked to go and get your own legal advice, can that be piled in with the loan, or do you have to pay for it yourself up front?
I suspect it depends on what everybody agrees.
Yes, and very often, in fact, these sorts of matters are dealt with by the broker, and if there's an established practice in the bank to add it to the security, then that element will go through on the nod, one would have thought. If not, then of course it may impose a cost burden on the applicant, but it is a cost burden, in my submission, to be envisaged, adumbrated in the hundreds of pounds rather than in the thousands of pounds. If one enters the realm of setting aside the judgment below and applying the Ettridge test as it stands to the findings of fact, were that to be one outcome, that again would not present undue difficulty in any event, because that test is two questions. Question one, is it a surety transaction? And question two, was it in respect of a non-commercial relationship? And so the simplicity of my proposed test is also actually reflected in the simplicity of the original test, albeit without necessarily reflecting the facts of this case. The notion of the imposition of a condition, I think I've dealt with that already. It shouldn't really make any difference. The question is, in a case where the lender discovers the debts and insists they are discharged, and the lender sees that the debt is husband's motor car finance debt, apparently, and a husband's credit card debt, then I do submit that places the lender on inquiry, whether or not it requires that borrowing to be discharged, because it generates, that factual scenario generates a surety dynamic.
What would happen if they both had car finance and it was a condition that both cars were paid up?
I suppose again it might depend on the facts.
So at that point it becomes a matter of fact and agreed at.
It might do. I certainly concede that, and it might depend on the car, I suppose, and comparison between them. But at this time of the day, I'm hard pushed to think of a sensible answer really to that particular example.
But presumably it would naturally follow from your test, your version of the test, that any non-trivial difference.
Yes, it would.
Would tip the balance.
Well, it would. If the relevant test is the test I'm proposing, then depending on other factors, the answer is yes. The bank would be on inquiry of a surety element, non-trivial.
The consequence might very well be that they both have to get advice.
Both have to.
If she's taking on his car debt and he's taking on hers.
I'm sorry, I didn't quite hear that.
On the face of it, I mean, it's not always a gendered thing, that if she was having her debts paid off as well as he was, then on the face of it, your logic would seem to suggest that they should both have independent legal advice as to whether they wanted to take on the borrowing. I suppose there might come to a point where it was only a few quid between the two, might be considered to be de minimis. But otherwise, the logic would seem to be that they should both be asked to assure the bank that they were up for this, on your logic.
In my submission, one applies the test. It has to be a versatile test if there is a surety element. And I know I'm reciting the same test rather than answering the question. But if there is a surety element, then the bank is on inquiry, which simply requires the bank to ask and to look a little bit closer, more closely at at what is going on. That's all one is suggesting. And it may be, or it may not be, that particular scenario, which is purely hypothetical, would engage the test. As I stand here at the moment, I'm not sure, to be honest. I have to give it some more thought.
Thank you. Right.
So, how are we doing in replying to the submissions for the bank?
Sorry, may I just take instructions, please?
Please read that out because it explains the application form. We can provide you a mortgage application to grant, never mentions house, not a property. And also it's for debt consolidation, including specific. It is because it's what she said. Please read that out. Please read that out.
I'm
clarity.
instructed unequivocally to read out.
Please just read it from there for the court and for clarity.
For clarity and in reply to learned friend, the mortgage application form stated it was to buy a, quote, plot of land, not a property, and also that it was for, quote, debt consolidation, including specifically to pay off Mr Bishop's credit card debts and his car loan at £39,500 at that time.
Can we have the reference
One
to
thing
the
that
mortgage
occurs-
application, please?
I was about to say, one thing that occurs to me is, and I've wrestled with this for some time, as to how much you need to have here just to see what was going on. And we did provide a slim file of further materials for the judge below. I haven't done that for this
No,
court.
but I think that all we need is reference to where the judge describes it. Maybe I can just search for it now.
Well, is it in the judgment, or was the mortgage application before the trial judge? I
course,
assume
yes.
it was.
Yes,
Um,
there's an awful lot before the judge.
but
So-
it's not before us. We haven't got that supplementary material.
No, you haven't. And
And I'm not.
it may be that, just dealing with this point, that as a matter of basic human interest, if nothing else, that
Yeah,
you may be assisted by some of these documents, but then of course, where does it end? So my friend and I would have to
I would
agree
much
on-
prefer, personally, the lady I think does want to see it, but I'd prefer personally to see how the judge at either stage dealt with the mortgage application.
Yes.
And I'm so far,
One of the problems, if it be a problem, is that we had internal underwriting material as well, as I recall, which was quite detailed.
it's really quite complex, I suspect, and quite difficult for us to get our heads round afresh.
Yes.
The judge at 116 says the application form for the loan identified the solicitors acting for the defendants as stated the purpose of the remortgage was the purchase of family share. Oh, this is in Halifax in another case. Sorry, to help. So, yeah.
Does the trial judge or the judge below actually describe what the mortgage application said? Page 40, paragraph 44.
105. Lovering thinks 105.
Well, 27, Mitchell 27, rather the claimant asserts this was a straightforward case of a joint application for a joint mortgage on jointly owned land, largely to pay off existing lending and to release some equity. And then thereafter at 37, as part of the mortgage application, Richardson agreed it was likely the broker would have lodged proof of income.
Take into account.
Set to there.
44, the judge is actually taken to the mortgage application. It
Yes.
doesn't clearly set out.
Oh, that was the Pilford Heath point, yes.
Yeah.
My friend suggests 52.
And the mortgage application is referred to 52. Yeah.
Oh, okay. It does refer to the credit cards and the bank loan.
He referred to box 42, which set out the bank was being told the remortgage was
I mean,
about.
To be fair, technically, if the trial judge is referring there to specific documents, then he has read them into this judgment. So you would be entitled to look at them if that would be of assistance. I'm sure we could deal with that quite quickly.
Well,
I'm sorry, what paragraph were we last at?
it was
Sorry,
60,
At 52.
52.
Oh, Judge Mitchell.
Yes. I'm sorry, it's page
Thank you. I've got
108.
it. I've got it.
I mean, the only problem with it is it says that, as we were told by everybody, that the mortgage application referred to the debts, which it obviously did. It doesn't say, it's unclear, paragraph 52, as to whether the reference was they were asking for money to pay off those debts. My understanding is that it was a condition imposed by the bank. They knew about the debts from the application form and then imposed a condition, because that's what the judge said. Yeah.
Somebody must have
Yes.
in the room.
I mean, have we not got the document somewhere?
We certainly have, but
Well,
whether I can
look,
simply-
I think we're not going to tarry too long on this. I think it would be useful to us to see this document. Can you agree what it is and send
Yes.
it to us, please?
Yes, we'll do it by agreement.
By 10:30 tomorrow morning.
Thank you.
No, I don't want it late. All right. Now, is there anything else, Mr. Beaumont?
No, there isn't. Not in reply. May I just double check?
Yes.
No, that's all. Thank you very much.
Well, anything else?
No, thank
you. Well, we will take time to consider our judgments, and when we have done that, we will hand them down in the usual way. Mr. Beaumont, that and Ms. Hulker, and we require that you try to agree an order and the disposition of costs, and you use the draft judgment only for that purpose and not for any other purpose, please. And if you are unable to agree costs and the order, then we will not hear oral argument on that point, but simply receive written submissions, which we will make directions about if you can't agree. But I'm sure you will be able to. Can I take this opportunity of thanking you both for an interesting argument, thanking your solicitors, Ms. Hulker, and thanking your client for her courtesy in letting you make your submissions. It's been an interesting and I would say difficult case, and I think all parties recognise that. So we'll have our work cut out to decide the right answer. Thank you very much.
That's great. Thank you.
Right, Tim.
So,
Don't forget the live stream.